This presentation is a production of the Iowa State Bar Association with assistance from the Iowa State Bar Association Foundation, the Young Lawyers Division, and the Iowa State Bar Association Center for Law and Civic Education. Opening statement is the first opportunity that each team has to present its case and to tell its side of the story. Opening statement is also the first time that the judges who are hearing the case have a chance to learn what the dispute is about and how each side intends to present the evidence that's available. The student lawyer who delivers the opening statement for each team must assume that none of the judges hearing the case is familiar with the facts, the issues, or the parties. A well-done opening statement will provide that information to the judges and will answer questions that they may have about the facts, the issues, and the parties. If the judges have questions about the facts, the issues, and the parties once the opening statement is completed, the student attorney has failed in his or her effort. To accomplish the goal of providing the judges with information that they need about the facts, issues, and parties, a good opening statement should be well organized and concise. Keep in mind that there is a 4-minute time limit for an opening statement. The opening statement should provide a good picture of what the case is about. It should factually discuss the evidence that will be presented. The evidence needs to be presented in a factual manner. Argument in opening statement should be avoided, except for a prayer for the relief sought. The opening statement needs to present the theme of the case and provide a checklist of items the judges should look for during the presentation of each side's case in chief. A well-organized, concise opening statement will allow each of the judges to have a command of the facts of the case and an understanding of what is going to follow. A good opening statement will give a clear understanding of the theme of the case, as well as the relief that is going to be requested when the case is submitted to the judges for their decision on the merits. The student lawyer who gives an opening statement may use a chart or piece of demonstrable evidence. This can be a helpful device to keep the student's presentation on task and theme. It can also help the judges better understand the points the student is making about the facts, issues, and parties. Keep in mind, the demonstrable evidence may be no larger than 24 by 36 inches. A well-done opening statement has a clear, easily understood theme and is organized so that the judges clearly can identify the issues, the facts, and the parties.
May it please the court, opposing counsel. Shakespeare once said, "So rash, so young, they say never live long." Ricardo Romista was young. Ricardo Romista died young, and although we cannot bring him back, we must ask ourselves, was he being too rash when he recklessly decided to drink, causing him to fall and then later die? By taking these risks, he took the chance to die. It all started with a party. Ricardo Romista was known for being wild and reckless, and at this party, that recklessness cost him his life. He went to a party and got drunk. So drunk, he had a blood alcohol level of 0.09. He then decided to get away from the party. He went onto a balcony and lost his balance, causing him to fall 20 to 40 feet, landing on gravel and pavement, severely injuring his left side and causing numerous abrasions. He was taken to the hospital and there died. The plaintiff said that Ricardo Romista climbed a roller coaster in the Prince of Denmark amusement park just to see a ghost and join a society called the Gravediggers. They said that Claudia Dana, the defendant, was negligent in securing her amusement park, and therefore his death is her fault. Who to believe? The plaintiff has the burden of proof and must prove through preponderance of evidence that Claudia Dana was negligent in securing her amusement park. They will fail to meet this burden. Though, if by any slim chance you find Claudia Dana negligent in any way, you must take in consideration the following. For Claudia Dana to have been negligent in securing her amusement park, she must have failed to properly secure the amusement park. She must have failed to maintain a sufficient and adequate fence. She must have removed the safety rails from the roller coaster. She must have removed the lighting from the park. She must have failed to properly supervise her park, and she must have failed to permanently dismantle her park in a safe and timely manner. Your Honor, this case deals with comparative negligence, and in order for we, the defense, to prove this, we must prove the following propositions. That the plaintiff knew the risk was present, that the plaintiff understood the nature of the risk to himself, and that the plaintiff freely, unreasonably, and voluntarily took this risk. And finally, that the plaintiff's assumption of the risk was the proximate cause of his damage. We will call 3 witnesses to prove our claim. Claudia Dana, the owner of the amusement park, will testify that she had excellent security measures, and because of these measures, Mr. Brumista did not die in her park. Mr. Schultz, the guard from the respectable employer of CSI, will testify that he was there the whole time, and the only person who came to the park was Mr. Dale Small. And finally, Mr. Kranz, a student who knew Mr. Brumista, who will testify that he was at the party in which Mr. Brumista died. Your Honor, the plaintiff said that Mr. Brumista climbed the roller coaster. The evidence will show otherwise. Your Honor, this case deals with circumstantial evidence, bias, and contradictions. We ask that you listen carefully and ask yourself, what motive does the plaintiff witnesses have to find Claudia Dana negligent? Or more importantly, what are they covering up about Ricardo Brumista, a rash young man who chose not to live long? Thank you, Your Honor.
An issue that often arises during opening statement is whether the student attorney should use notes. As a general rule, a well-organized and presented opening statement that is delivered without notes should receive consideration for a high score from the judges. This demonstrates that the student lawyer has made extra effort and preparation. This type of presentation should receive more points than a well-delivered opening in which the student lawyer uses substantial notes. By the same token, a well-delivered opening with only a few references to notes should be considered for a high score. Finally, a student lawyer who reads from a script should receive fewer points. Done properly, an opening statement sets the theme and the tenor for the remainder of the trial and assures that the judges have a clear understanding of the facts, the issues, and the parties in the case that they are hearing. This presentation is a production of the Iowa State Bar Association with assistance from the Iowa State Bar Association Foundation, the Young Lawyers Division, and the Iowa State Bar Association Center for Law and Civic Education. Direct examination is perhaps the most difficult task that a student lawyer has to perform in mock trial. Direct examination requires thorough preparation. The student lawyer has to consider how to prepare questions which will elicit the needed answers from the witness. When conducting direct examination, the student lawyer must ask questions in a way that advances the case without suggesting the answer to the witness. Unlike cross-examination, leading questions cannot be used in direct examination. In other words, the student lawyer who conducts a direct examination cannot pose a question such as, "Well, Mr. Witness, isn't it a fact that you were not at the scene?" Direct examination requires carefully crafted questions that will generate facts that help to tell the story of the case. The student attorney who conducts direct examination has an advantage. The attorney and the witness are members of the same team. During practice, they should learn to work with each other and to cooperate. This will allow the witness to know the answers to give to the student attorney's questions. This close cooperation is essential. Witnesses and student attorneys who have prepared the direct examination and understand the facts that are needed to establish the case will each score well. The student attorney must know and have a command of the witness's testimony so that all relevant evidence and material can be presented in a proper fashion. Again, the attorney must use non-leading questions and have a rapport with the witness so that the testimony flows and helps develop the theme of the case. The witness has to work closely with the examining attorney. The witness must know all of the facts and reasonable inferences related to his or her part. The witness needs to understand the information that he or she has and which will be presented. It is through the witness on direct examination that the facts of the case are presented, and they must be presented in a manner that the judges hearing the case will gain a better understanding of the facts and the issues. A well-presented direct examination will flow. It will be an easy-to-follow dialogue between the student attorney who is asking the questions and the witness who is responding.
May I call our next witness?
Plaintiff calls Dale Small to the stand.
You swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please. Be sure to speak up.
Okay. Excuse me, Your Honor, would you like the exhibits that have already been admitted into evidence?
Yeah, you may keep them there in case you need to use them.
Yes, Your Honor. Please state your name and spell your last name for the record.
Dale Small, S-M-A-L-L.
How old are you?
I'm 73 years young.
Tell us a little bit about yourself.
I live in Gardner Lake, Iowa, and I'm currently retired, and I'm also a widow.
You say you're currently retired. Where did you retire from?
Well, for over 40 years, I worked at the Prince of Denmark Amusement Park.
And in that time, did you hold any positions?
Yes, I held a number of positions, ranging from snack bar to security.
In what year did you become a security guard?
1998.
And what shifts did you work?
I worked primarily the night shift.
You also said you are currently widowed. Who were you married to?
I had a lovely spouse named Reese.
What was Reese like?
Anything you could look for in a spouse. Caring, loving, everything.
Mrs. Small, what happened to Reese?
Objection, Your Honor. I do not see how this is relevant to know what happened to Reese. It is not relevant to the ultimate issue, which is whether or not Miss Claudia Dana was naked.
Is there any relevance?
Yes, Your Honor. The whole point of this was going to a gravedigger society and getting a nation initiated to see the ghost of Reese Small.
Objection's overruled.
Yes, Your Honor.
Would you like me to please repeat the question?
Yes, please.
What happened to Reese?
Well, Reese and I were newlyweds, and we were on our honeymoon, and we went to Okoboji, and the new Prince of Denmark Amusement Park coaster, Flying Buttress, and we got on the ride. Reese and I were on, and it gave a funny jerk, and Reese fell off to his death.
Mrs. Small, did you ever see Reese again after that?
Yes.
When did you see Reese again?
Next year, October 31st,
And what year was this?
1956.
And what had Reese? What did you observe of Reese?
Well, I was walking around the park after hours, and I saw something. At first, I thought I was crazy, and I looked up, and it appeared to be Reese, and he even spoke to me.
What did he speak to you to?
Objection, Your Honor. This is hearsay.
Your Honor, first of all, can a ghost really commit hearsay? And also, and this is not being offered to prove the truth of the matter asserted.
Objection is sustained.
Thank you, Your Honor.
What did you observe? What did you observe to the extent of Reese?
Just, he looked very real and very alive.
And do you think Reese was a ghost?
I'm sorry, I couldn't
Do
hear
you
you.
think Reese was a ghost?
It was almost too close to tell, but that would be the only thing that would almost make sense to me.
You stated before you worked at the Prince of Denmark Amusement Park. Who was your supervisor?
Well, for many years I had a lady named Gertrude Dana, and then her daughter, after Gertrude died, named Claudia Dana.
Do you know what year Claudia Dana took over the park?
1991.
What? You also said you're currently retired. What ended your employment?
On October 30th, 2000, I was informed the park was closing down.
And how did you take to this news?
Well, I was upset. I mean, anyone in my circumstance would be. That was my last link to Reese, and the roller coaster was the sure thing. So I said a few things I shouldn't have, and I regret saying it, and I was fired. But if I was Claudia, I would have done the same thing.
Let's discuss the year of 2001. Was the Flying Buttress still standing that year?
Yes, it was.
Were you surprised by this?
Not particularly.
Why weren't you surprised by this?
Well, I spoke to Claudia Dana's secretary, Preston, and he told me that they were holding out to get as much money as they could for the Flying Buttress.
Let's discuss the day of October 31st, 2001. What did you do that night?
I went to the park as I usually did.
At the park, what happened?
Well, I was walking towards the gate when I met up with the new security guard, Mark Schultz.
Your Honor, may I approach the witness?
Yes.
Let the record reflect on showing opposing counsel what has been previously omitted as Exhibit 3. Let the record reflect I am showing the witness what has been previously omitted as Exhibit 3. Do you recognize this?
Yes, I do.
What is it?
It's the diagram of the Prince of Denmark amusement park.
Your Honor, may we post an enlargement of Exhibit 3?
Yes.
Your Honor, may I move so that I may see the exhibit?
Might wait till it posted, and then you'll be able to do it if you can't see it.
Your Honor, may the witness approach the enlargement?
You need to move.
Yes, sir.
You may. And yes, you may.
You testified earlier that Mark Schultz was there. Who is Mark Schultz?
The new security guard that Dana hired.
And where did you see Mark Schultz?
Right about there.
Can you please mark an MS for Mark Schultz?
It was right about where this SG is.
And can you also mark your initials where you were talking to Mark Schultz?
Right about here where his fellow Ellie.
And about what time was this?
Well, I met up with him at about 11 o'clock.
And what time did you end your conversation?
We talked for about a half an hour, so I'd say around 11:30.
Can you please mark 11:30 on the board, please? What did you do next?
I began walking towards the flying buttress.
How come Mark Schultz let you into this building?
He was very sympathetic to my situation, so I very much appreciated it, and he allowed me to enter the park.
Can you please mark your route taking to the flying buttress?
Well, I was walking along, and I got about to here when I heard some people talking.
What did you do next?
Well, I went to find Mark Schultz because I figured kids were trying to climb the roller coaster again.
Can you please, where did you find Mark Schultz?
I eventually found him at their house, but I had to go all the way down the dance hall. And I also, when I was walking towards him, I heard a scream as well.
Where did you go next?
Well, after I found Mark, which took me about 15 minutes, we started walking towards the flying buttress.
And what did you observe at the flying buttress?
Well, as soon as we got in there was a cap with the letters U and O on it, and the fence was literally flattened. It looked like a car had run over it.
Oh, where was this flattened fence at?
It was right about where this X is.
Can you please mark a circle around the X? Have you done so?
Yes.
You may be seated. What did you do next after you saw this flattened fence?
Well, Mark told me to leave, and something definitely was wrong, so...
Objection, Your
I
Honor,
think it's
and I ask that my objection precede the witness's response, and the witness's response be stricken from the record. The witness has begun to testify to hearsay.
In response,
Your Honor, this is an admission by party opponent because Claudia Dana Mark Schultz was under the supervision of Claudia Dana.
Your Honor, this is not an admission, Mayor Schmuck, Your Honor.
yes.
Your Honor, this is not admission by a party opponent because it does not go against the interest of my client.
The objection is sustained. The last comments of the witness are stricken.
Thank you, Your Honor.
What did you do next?
Well, I went to Claudia Dana's house.
And then what happened at Claudia Dana's house?
Well, I had to bang on the door for around 15 minutes, and she came out and accused me of being drunk.
Objection, Your Honor, and I ask that my objection precede the witness's response, and the response be stricken from the record. She has testified to hearsay.
This is an excited utterance and an admission by party opponent.
Your Honor, may I respond?
The objection is sustained.
Thank you, Your Honor.
Who was at the house that night?
Claudia Dana,
Are you certain to your knowledge that it was only Claudia Dana at the house?
yes.
What happened at the house next?
Well, I had to bang on the door for around 15 minutes.
Objection, Your Honor. This question has already been answered.
Objection is overruled.
Yes, Your Honor.
I had to bang on the door for around 15 minutes, and all I wanted to do was tell Claudia that kids are trying to climb the roller coaster again.
And what happened next?
Well, she came out and accused me of being drunk.
Objection, Your Honor, and I ask that my objection precede the witness's response, and the response be stricken from the record. This is hearsay.
Your Honor, this can be a present sense impression too.
Your Honor, may I respond?
Go ahead.
Your Honor, this would not be present sense impression, because she would not be describing an event that she was seeing at the time.
It appears that it was a present sense impression. The objection is overruled.
Yes, Your Honor.
Would you like me to restate the question?
Yes, please.
What happened after Claudia Dana came to the door?
She just accused me of being drunk, and on top of that, she threatened to call the cops when all I was trying to do was inform her that kids were trying to climb her roller coaster.
Were you drunk the night of October 31st, 2001?
No,
When was the last time you did have a drink?
it was so long ago. I'd say at least 5 years ago.
Your Honor, she's run out of time. I have no further questions, Your Honor.
Direct examination is an art. It requires well-crafted questions on the part of the attorney who is directing the witness, and it demands a witness who is well aware of the information that is needed to help establish the case in chief. A quality direct examination will be well practiced and seem effortless on the part of both the attorney and the witness. A good direct examination will provide a solid foundation for the case in chief. It will enhance the witness's credibility with the judges who are hearing the case, and it will allow the witness to handle the cross-examination performed by the opposition. In their evaluation of a direct examination and the witness's performance, judges will consider the quality of the questions posed, the responsiveness of the witness, the preparation of both the student attorney and the witness, the way that they worked together to provide the information needed and necessary so that the judges could understand the case and decide the issues involved. A quality direct examination should answer any questions that the judges have in their minds about the witness's knowledge and information and how it develops the case in chief. This presentation is a production of the Iowa State Bar Association with assistance from the Iowa State Bar Association Foundation, the Young Lawyers Division, and the Iowa State Bar Association Center for Law and Civic Education. Once the direct examination is over, one of the student attorneys from the opposing team is allowed to cross-examine the witness. Cross-examination is a chance for the student witness to demonstrate his or her ability to think and to deal with the unexpected. The student attorney who performs cross-examination has a chance to point out problems with the direct testimony, the witness's bias or lack of knowledge. The attorney performing cross-examination needs to use leading questions, questions that will elicit the answer the attorney wants. Leading questions suggest the answer. Just as in direct examination, the attorney who is conducting the cross-examination must know the questions which need to be asked and the best way to ask the questions to get the response desired. The witness has to work diligently to avoid agreeing too much with the attorney who performs cross-examination. It's difficult to do, but a good witness, one who is well prepared and knows his or her story, will be able to accomplish the task. The attorney conducting cross-examination has to be careful. The attorney should never ask a question to which he or she does not know the answer, and the witness should never be asked why during cross-examination.
Then cross-examine.
Thank you, Your Honor. Now, after your work at the Prince of Denmark Amusement Park, you were transferred, correct?
Correct.
And this was to guard a grain elevator in northern North Dakota, wasn't it?
That's true.
Now, Mr. Schultz, this isn't a promotion, is it?
Objection, Your Honor, relevance. This trial is to prove whether or not Miss Dana was negligent, not to prove what jobs Mr. Schultz had after the
May I
accident.
respond, Your Honor?
Go ahead.
This goes to the witness's credibility.
Your Honor, may I respond?
Go ahead.
Whether or not Mr. Schultz had another job after the Prince of Denmark Park does not go to his ability to tell the truth.
Objection is overruled.
Yes, Your Honor.
This isn't a promotion, isn't it? Is it, Mr. Schultz?
I don't know. To me, it just seems like they're sending me out to work for somewhere else.
Is that a yes or no?
Then I don't know.
Now, some of your coworkers call you Sergeant Schultz, correct?
Correct.
Are you aware of the 1960s television show Hogan's Heroes?
Objection, Your Honor, relevance. This does not go to the ultimate issue, which is whether or not Mrs. Dana was negligent, not whether or not he's seen a television show.
Overruled.
Thank you, Your Honor. Are you aware of the 1960s television show Hogan's Heroes?
No, I'm not.
In this television show, did you know that in this television show, there was a POW camp guard named Sergeant Schultz who always claimed, I see nothing, I know nothing?
Considering that I haven't seen the show, no. No.
But you would never say anything like, I see nothing, I know nothing, to avoid blame like that Sergeant Schultz did, would you?
Could you please repeat the question?
You would never say anything like, I see nothing, I know nothing, to avoid blame like that Sergeant Schultz did, correct?
I don't know.
Now, on the night of October 31st, 2001, this was your first and only time working at the Prince of Denmark amusement park, correct?
I believe so.
Your Honor, may I approach the witness?
Yes, sir.
Let the record reflect that I'm showing opposing counsel what has been previously marked as Exhibit 4B. Let the record reflect that I'm handing the witness what has been previously marked as Exhibit 4B. Do you recognize this exhibit?
Yes, I do.
What is it?
It is the guard report shift log from CSI.
And why is it made?
To show what time clock I was at what time.
To show you were doing your job, correct?
That's true.
And in any way can this be tampered with?
Not to my knowledge.
Is this a fair and accurate representation of your lines of security that night?
Yes.
Your Honor, I move that Exhibit 4B be admitted into evidence.
Any objection?
No, Your Honor.
Plaintiff's Exhibit 4B is admitted.
This can also be found in your trial notebook. May I post an enlargement of Exhibit 4B?
Yes, sir.
May I also post an enlargement of Exhibit 3, which has previously been admitted into evidence?
Yes, sir.
May the witness approach both enlargements?
Yes, sir.
Your Honor, may I move so I can see the enlargements?
You may.
May I approach the witness, Your Honor?
Yes.
Will you please circle the 2 times that you were at clock 8 on your security log?
What date?
The times that you were at clock 8, which is the flying buttress as seen on Exhibit 3, Your Honor. Only 2 times?
From this exhibit, yes.
Now will you please mark your initials MS and Dale's initials DS where you had an encounter with him that night on Exhibit 3? So you had left the park's perimeters that night when talking to Dale Small, correct?
I guess so.
Now will you please write the time 11:40 next to clock 2 where it's shown that you were at on Exhibit 4B? Now this was 20 minutes before midnight,
Correct.
and you were at the opposite end of the park from the Flying Buttress, weren't you?
Yes.
Now will you please mark 11:55 as shown on Exhibit 4B next to clock 3? Thank you. Now this was 5 minutes before midnight, wasn't it?
Yes.
Yet you were at the farthest possible point away from the Flying Buttress within the park limits, weren't you?
I guess so, yes.
And while you were at clock 3, both the movie theater and dance hall were standing in your line of vision, correct?
Correct.
So you saw nothing, right, Sergeant Schultz?
Well, of course I saw something. I'm not blind. But I couldn't see the flying buttress.
Thank you. No further questions, Your Honor.
Before conducting cross-examination, the attorney who is going to question the witness needs to assess and be aware of everything that was said in direct. A good cross will focus on inconsistencies, misstatements, and lack of candor on the part of the witness. A well-executed cross-examination can be devastating and can make the most convincing direct examination of a witness suspect. As they evaluate a student attorney's cross-examination, the judges will consider whether the questions asked affected the credibility of the witness or brought forth relevant and material information that was not presented in direct examination. The judges will also evaluate if the student attorney used leading questions to his or her advantage in order to control the witness and to present the student attorney's theory of the case. A cross-examination that is well structured and pointed will be scored highly. A cross-examination that rambles and fails to bring into question the witness's credibility or veracity will be scored lower. The judges will consider whether the witness meekly answered yes to each of the leading questions posed by the attorney conducting the cross-examination, or if the witness attempted to turn the question and provide a response that was consistent with direct testimony. A witness who stays in character and refuses to agree to points made by the student attorney on cross-examination, which are not right, should receive a higher score than a witness who readily agrees with every point and seems to want to get off the stand just as quickly as possible.
Objection, Your Honor.
Objection, Your Honor. Lack of foundation.
Objection, Your Honor.
Objection, Your Honor. Unfair extrapolation.
In mock trial, judges are able to determine how well prepared a team and its individual members are by the way objections are made and how team members respond to objections made by the other side. Making objections the right way and being able to explain to the court why an objection is made requires knowledge of the rules of evidence as well as mock trial. Practice is critical in order to make good objections and to develop the skills needed to know when to object. Jim Van Dyke is a lawyer from Carroll. He is a successful mock trial coach both at the junior high and high school levels.
The first thing that's important is when to make the objection. And there are judges who say you should go ahead and stand up and make that objection as soon as the objectionable material starts to come into the answer. Others say you better wait until the answer is all the way in. It's impolite to interrupt, so you probably should just wait. When the answer is done, then you stand up, make the objection. Your Honor, I object, and I move that my objection precede the answer and that the objectionable portion be stricken from the record.
I ask that my objection precede the witness's response, that it be stricken from the record.
My perspective is the polite way. That is, wait for the answer to come in. Now, there are times you can make objections before the answer. If that question is so obvious that it calls for objectionable material, you can go ahead and make the objection before the answer. In fact, that's really best. But most of the time in mock trial, you won't get that opportunity. You'll have to wait, you'll hear the answer, and then you stand up and, in addition to the objection, make the motion to strike.
How should a student lawyer respond, or must a student lawyer even respond if the presiding judge asks a question about the objection that's been made?
I think it's very, very important for the other side to respond. I think that usually the method I prefer is that you get on your feet, Your Honor, may I respond, please? And then 9 times out of 10, the judge will say, yes, you may, and be ready for your response, not only with why you think the matter or the objection should not be sustained, but also, if you have it, a rule number is very preferable, that, Your Honor, under Rule 703, this is properly admitted evidence because. And then the person making the objection is allowed one further argument in support of his or her objection.
There are a number of objections available to mock trial attorneys, but there are 5 which are most frequently used. They are relevancy, foundation, hearsay, lack of personal or professional knowledge, and unfair extrapolation.
Where did you all grow up at?
Well, we're all from, Iowa. Like, again, Vermeer is kind of outside of Pocahontas.
Objection, Your Honor. This question is irrelevant to the case at hand. It doesn't matter where the band members grew up.
Relevancy is probably the single greatest objection that any mock trial student can learn. And relevancy simply means, is it important? Does it advance the case or not? If I ask you what you had for lunch, that is probably irrelevant unless the trial might be something like a case involving, say, alcohol consumption. And the expert witness would say that the rate of alcohol consumption can be affected by food intake. So relevance is very, very vital to understand, and it just comes down to, does this question, does this answer advance the case?
Objection, Your Honor. Lack of foundation.
Foundation is pretty much like it sounds. Foundation would be the building blocks that you must put underneath the evidence before it can be admitted. And I like to tell the students I coach that it's the 5 W's. It's the who, what, when, where, and why. Who made this exhibit? Why was it made? When was it made? What purpose does it serve? and then you offer the exhibit or you offer the question, but only after you've done the building blocks of the foundation first.
Objection, Your Honor. The witness has just begun to testify to hearsay.
Lawyers have made a living writing books on the question of hearsay, but very simply, and the way I coach the students is to recognize hearsay by, I heard someone else say. And if you hear the witness start into that sequence, you know that hearsay is coming. Or if the question says, what did you hear someone else say, then you object immediately. Hearsay is an out-of-court statement made by someone other than the witness who is now testifying that is offered to prove the truth of that statement. So there's three parts. It's out of court, made by somebody other than this witness, and it's offered to prove the truth.
Objection, Your Honor. The witness has no personal knowledge in the area they're questioning.
Lack of personal knowledge in mock trial usually means that it's outside the witness's statement, because our rules require that the witness stay within the limits of the given facts in the statement. And that means that the witness is not even bound by things in another witness's statement, just his or her own statement. Then there's the professional part of that same objection, which usually relates to an expert-type question. If I ask a mechanic about a medical question, it's going to be lack of professional knowledge. But if I ask a doctor about a mechanical question, the same thing. So an expert, the objection very often is, Your Honor, the witness lacks professional knowledge to give this opinion.
Objection, Your Honor. Unfair extrapolation. The witness has begun to invent facts.
This objection, as you know, does not exist in the rules of evidence for either the federal or state courts. But in mock trial, we are confined to the 6 witness statements and the exhibits, and it is very, very limited on direct examination, somewhat more open on cross-examination, where witnesses can add a few facts that are not in the statements, but only if they do not unfairly change the emphasis of the trial or the direction of the trial. It's one thing to invent a fact to say that I saw a blue car drive down the street when it isn't a real big point in the case. It's another thing if that blue car happens to be the one involved in the accident, in the case involved, and the car actually happened to be yellow or some other color. So if you're inventing a fact that affects the case, the objection is unfair extrapolation. Your Honor, the question asks the witness to invent facts.
My name is Katie Cluse, and my team and I are representing the defense in today's case.
Pretrial conference is very important. It sets the tone for the entire trial. You are establishing a professionalism with the judges. You are showing the judges that you're prepared, you're confident, you're strong. You have a checklist. You're going through the introduction of your teammates. You're going through the stipulations. You have usually a pretrial notebook to hand to the other team and to the judges with all the exhibits and the witness statements to show that you are ready for this trial. And also, it's important at the pretrial conference to bring up some key points that you think might lead to rules questions in a particular trial. If you think that there might be something the judges should be alerted to, bring that up at the pretrial conference. And always remember, for the plaintiff's side or prosecution side, reserve time for rebuttal on final argument. There are only 2 times to do that, and one of them is at the pretrial bench conference.
Relevancy, foundation, hearsay, lack of personal or professional knowledge, and unfair extrapolation are not the only objections that are available to a mock trial lawyer, but they are among the most powerful. With practice, the skills to use these objections successfully can be developed, and you as a mock trial lawyer will be able to prevent the other side from presenting evidence and testimony that could hurt your case. This has been a presentation of the Iowa State Bar Association, the Iowa State Bar Association Foundation, and the Young Lawyers Division of the Iowa State Bar Association. This presentation is a production of the Iowa State Bar Association with assistance from the Iowa State Bar Association Foundation, the Young Lawyers Division, and the Iowa State Bar Association Center for Law and Civic Education. Closing argument is the opportunity for the student attorneys to gather the evidence they presented during their cases in chief and then present cogent reasons why their cause should prevail. It is indeed argument. Unlike opening statement, a closing argument requires the student attorney to persuasively tell the judges why his or her case is the more meritorious. The student attorney takes the facts and applies the law, and then urges the judges hearing the case to find in his or her favor. A successful closing argument is going to return to the opening statement. It will reassert the theme of the case. A well-organized closing argument will recall for the judges the facts, the issues, and the parties. This will help to reinforce for the judges the evidence that they have heard. A good close will recap the favorable evidence and downplay the evidence that does not support the proponent's case. A good close will take the positive facts and relate them to the law of the case. A good closing argument will be persuasive. It will give the judges cause to stop and to consider the information provided, and it will give the judges solid reasons to find in the proponent's favor. Each side is allowed 8 minutes for closing argument. It's essential that the time be used wisely to present to the judges reasons why the student attorney's case should prevail.
First of all, I'd like to thank the judges for taking the time to listen to our case today. Shakespeare once said, "So rash, so young, they say never live long." Unfortunately, this is the case for Ricardo Bromista. His actions point to comparative negligence, which is the key element of law in this case. Comparative negligence was proven through 4 claims, which I will discuss later in my closing. The plaintiff tried to prove that Miss Claudia Dana alone was negligent. The first defense witness we heard from today was Miss Claudia Dana, the defendant. She told us how she hired Officer Schultz, a guard, from a very respected security outfit. This guard worked from 7 p.m. to 7 a.m. every single day, from the very beginning of deconstruction to the last. She also told us about another safety precaution, an 8-foot fence. The second defense witness was Officer Mark Schultz. He also confirmed that the park was watched 24/7. He was on shift from 7 p.m. to 7 a.m., and the demolition crew was there the rest of the time. There was always someone watching the park. The last witness we heard from today was Mr. Ross Krantz. He told us about Mr. Bromista's nature. He tried to get Mr. Krantz to do all sorts of risky things like base jumping and climbing the flying buttress. It even scared Mr. Krantz a little. Mr. Krantz also told us how Miss Shaw told him that she and Mr. Bromista had been drinking and smoking before Mr. Bromista fell off the balcony that night. Beginning with the plaintiff witnesses, we have Miss Ray Shaw. She also told us about Mr. Bromista's nature. So now, Your Honor, we have 2 people who can testify that Mr. Bromista base jumped and skydove. Would a man like this hesitate to climb a roller coaster? Ms. Shaw also stated that Mr. Bromista fell on grass and dirt. And then we found out about her relationship with Mr. Bromista. They were, quote, best friends. Would you rather have your best friend be remembered as a victim of someone else's negligence? Or would you rather have people find out that he fell from the balcony in a drunken state? And lastly, we found that no one can place Ms. Shaw and Mr. Bromista at the park that night. Another plaintiff witness was Dr. Teeds. Dr. Teeds testified that Mr. Bromista was drunk. We have exhibits showing his alcohol level at a 0.09. We also have exhibits saying that he fell on gravel and or pavement. Where would gravel and pavement be, you ask? On the parking lot, under the balcony, at the party. Dr. Teeds even had 4 acquaintances who claimed they fell off the roller coaster. Bias? Yes. Another plaintiff witness was Miss Dale Small. One of the first things we learned about Miss Small is that she is still affected by her husband's death. Year after year, she goes back to see him. She even claims that he talked to her. Her husband, who died in 1955. That's roughly 50 years ago, Your Honor. How can we trust this witness's credibility? How can we trust that she heard voices and later scream, when she also claims to see her dead husband's ghost every year? Plaintiff themselves even made a joke about her seeing the ghost. If they can't take their own witness seriously, how can we? And lastly, we learned about Miss Small's drinking problem. In fact, that's why Miss Dana finally had to fire her. How do you decide the outcome? Ask yourself, do you find that Ricardo Bromista was injured at the Princess Denmark Park on October 31st, 2001? First of all, we have Mr. Krantz, who states that he saw them at the party and drove them to the hospital. Ask yourself, who can place Miss Shaw and Miss Bromista at the park that night? No one. Can you believe Miss Small, a woman who sees her dead husband's ghost on Halloween night? And finally, the most convincing point. The ER report stated that Mr. Romista fell on gravel and or pavement. If he had fallen off the roller coaster, would he have fallen into gravel or pavement? No. But if he had fallen off the balcony, would he have fallen into gravel or pavement? Absolutely. All this adds up to a no. However, if you still think yes to this first question, the second question you need to ask yourself is, do you find that Ricardo Romista acted negligently, approximately causing the October 31st accident? To prove this, we, the defense, had to prove 4 points. Mr. Romista knew the risk was present. We know he knew because Ms. Shaw testifies that he went to the park before they were supposed to go, saw that the safety rails were gone, and that most of the lighting was gone as well. He also knew that demolition was in progress and almost done. It is safe to say that Mr. Romista knew that falling from a roller coaster would seriously injure him if it did not kill him. Nevertheless, Mr. Romista took that risk unreasonably, freely, and voluntarily, and according to Ms. Shaw, was very excited about it. And finally, we had to prove that the plaintiff's assumption of the risk was the proximate cause of the plaintiff's damage. We know that, either way, Mr. Romista was drunk and fell from some height in the air. He chose to get drunk, and he chose to supposedly climb the roller coaster. No one is to blame but him. All this adds up to a yes. If you are still deciding who is negligent, you should ask yourself, do you find that the defendant acted negligently, approximately causing the October 31st accident to decedent Romista? To prove this, the plaintiff had to prove 6 points. Miss Claudia Dana got a guard from one of the most respected security outfits in the Midwest. She had the park watched 24 hours a day. She had a fence that exceeded building code requirements. And this fence had to be locked and unlocked. That sounds like a lot of safety precautions to me. The fence was 8 feet tall. It didn't just meet building code requirements, it exceeded them. By the time Mr. Romista supposedly got to the roller coaster, the flying buttress was being taken down the next day. The safety rails had to come down sometime. Ms. Shaw states that Mr. Romista said that most of the lights were gone. That means that there were some left. Miss Dana had the park watched 24 hours a day. And finally, plaintiff had to prove that Miss Dana was grossly negligent in failing to dismantle the roller coaster in a safe and timely manner. Miss Dana didn't even use the extension that the demolition company tried to give her. She just followed their schedule. All this adds up to a no. The plaintiff has the burden of proof. They must prove, through a preponderance of evidence, that my client is guilty of negligence. They have not met that burden. This is a case of contradictions. Who are you going to believe? A best friend? An old woman who's lost touch with reality? A biased expert? Or would you believe a conscientious park owner, a security guard, a fellow classmate? Mr. Romista was a young, rash man who made the decision to drink that night, which ultimately caused his life to end too soon. Thank you.
A key fact to remember in closing argument is the student attorney representing the plaintiff or prosecution must reserve any remaining time to present rebuttal to the opponent's closing argument. If this is not done, rebuttal will not be allowed. A well-organized and presented closing argument demands passion and persuasiveness on the part of the student attorney. As an opening statement, a closing argument that is presented without notes or with minimal reference to notes should be scored higher than a closing argument which is read from a script. Also, the student attorney may use demonstrative evidence to reinforce the closing argument, but again, it may be no larger than 24 by 36 inches. Closing argument brings the mock trial to a close. It's now the time when the judges tally their votes, and then the judges will discuss their impressions of the presentations with each team. This presentation is a production of the Iowa State Bar Association with assistance from the Iowa State Bar Association Foundation, the Young Lawyers Division, and the Iowa State Bar Association Center for Law and Civic Education. Mock trial is an undertaking that involves not only individual effort, but also teamwork. Team performance is one of the categories which the judges hearing the case score. Team performance involves a number of intangible factors. Evaluation of the team includes the individual performances of the attorneys and the witnesses. It also allows the judges to comment on the way that a team and its members work with each other and react to their opponent. One of the first times the judges have to evaluate team performance is the bench conference prior to the beginning of the trial itself. At the bench conference, the judges will evaluate whether team members are prepared. Do they present materials that will assist the judges? Do they ask questions of the presiding judge that will help to advance the case? Do the student attorneys respond promptly and properly to the presiding judge's questions and instructions? During competition, are the team members courteous to each other, or are there little tricks being played upon each other's side in order to trip up a competitor? Do team members work with each other when there is a problem presented? While individual performances are important, helping a team member with an objection or proposing a question is a good sign of teamwork. Are the timekeepers for each side prepared? Do they understand their task? Do they help the presiding judge keep the case on schedule and on time? One purpose of mock trial is to help students understand the role of courts in resolving disputes. A trial is intended to be an ordered method to achieve a resolution of differences between two sides. Dispute resolution does not require rancor or disruptive conduct. Mock trial is individual and team competition that provides students with a clear example of how problems can and are resolved in a civil, dignified manner and fashion. In mock trial, it does not matter which team loses or wins, either on the merits or in terms of points received from the judges. Each student, by participating in mock trial, learns and gains skills and information that are going to last a lifetime. In mock trial, everyone who participates is a winner.